There are four categories of immigrants that ICE has explicitly prioritized for deportation in 2026, and I want to be very direct with you. Two of those categories may include people who believe they are completely safe, people with pending cases, people with work permits, even people who have been here for decades. If you or someone you love has any kind of immigration status in the United States right now, the next 8 minutes could be the most important 8 minutes you watch this year. My name is Raymond Crivello. I am a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. I do not deal in rumors. I do not traffic in fear. What I give you is policy, law, and verified information so that you can make informed decisions about your future and the future of your family. Before we go any further, please understand, I am not your attorney, and nothing in this video constitutes legal advice. This content is strictly for educational and informational purposes. Every immigration situation is unique, and you should always consult with a licensed immigration attorney about your specific case. Now, let's get into what is actually happening. We are going to break down exactly who ICE is targeting right now, in order of priority. This comes directly from DHS enforcement strategy documents, ICE's own operational releases, and verified policy briefings. This is not speculation. This is their stated enforcement framework. Priority number one, and this is the group ICE is most aggressively pursuing right now, is what DHS is calling the worst of the worst. This means individuals with violent criminal records, active gang affiliations, and what federal law classifies as aggravated felonies under the Immigration and Nationality Act. In early 2026, ICE launched two major coordinated operations, Operation Angel's Honor and Operation Twin Shield. These operations resulted in thousands of arrests within the first weeks of the year. The primary targets were individuals connected to transnational criminal organizations, with a specific focus on the gang known as Tren de Aragua, which has been formally designated under federal law. Under the Laken Riley Act, which was signed into law and expanded federal authority significantly, any non-citizen arrested for or convicted of a crime involving theft, burglary, or violence is now subject to mandatory ICE detention and expedited removal proceedings. This is a major shift. Previously, prosecutorial discretion allowed many of these cases to be deprioritized. That discretion has been formally and legally curtailed. But here's where this becomes critical, and I want you to pay close attention to this. The definition of aggravated felony under immigration law is not the same as what most people understand a felony to be in criminal court. Under INA Section 101A, 43, aggravated felony is a term of art. It includes crimes like theft with a sentence of 1 year or more, even if that sentence was suspended. It includes drug offenses that would not be felonies under state law. It includes crimes of violence with sentences over 1 year. This means someone who pled guilty years ago to what seemed like a minor offense may actually have an aggravated felony on their immigration record, and may not know it. If you have any criminal history, even old, even minor, even expunged, please, before anything else, sit down with a qualified immigration attorney and have that record reviewed in the context of immigration law. Priority number two is equally urgent, and it affects far more people than priority one. ICE's second enforcement priority in 2026 is individuals who have final orders of removal already on file, meaning a federal immigration judge has already issued a deportation order, but who have not left the United States. These individuals are classified as immigration fugitives, and ICE has significantly expanded its fugitive operations teams to pursue them. According to ICE's 2026 Enforcement and Removal Operations Strategy, the agency has increased its enforcement workforce capacity by approximately 120% compared to prior years. This expansion is specifically designed to accelerate fugitive operations in every major city, including cities that have historically limited local law enforcement cooperation with ICE. This is what many green card applicants and long-term residents are misunderstanding. A final order of removal does not disappear over time. It does not expire. It does not become less enforceable because years have passed. In fact, a person with a final order of removal who has been living quietly in the United States for 10 or 15 years is still fully removable, and under current enforcement priorities, they are actively being sought. Let me give you a realistic example of what this looks like in practice. Imagine a man, let's call him Carlos, who came to the United States 22 years ago. He has 3 children born here. He has a job. He pays taxes. But in 2009, he had a removal case, missed a court date because he never received proper notice, and a judge issued a removal order in absentia. Carlos did not know about that order. He has been living his life, but that order has been sitting in the federal system the entire time. In 2026, under current operations, Carlos is a Priority 2 target. His case can be acted upon at any time without a new hearing because the legal process was already completed, even if he was unaware of it. If you have any history of immigration court, any prior case, any missed hearing, any period where you were out of status, you need to verify your record with an immigration attorney immediately. In absentia, removal orders are more common than most people realize, and they are actively being enforced right now. There is one detail most people are missing, and it involves two issues that seem unrelated but are both accelerating rapidly in 2026. The first is TPS, Temporary Protected Status. Secretary Kristi Noem and DHS have announced the termination of TPS designations for multiple countries, including Yemen, Somalia, Venezuela, and Haiti. TPS is a humanitarian protection that has allowed hundreds of thousands of individuals to live and work legally in the United States because conditions in their home countries made return dangerous. When TPS is terminated, those individuals lose their legal status, and if no other immigration relief is available to them, they become deportable. These terminations are being challenged in federal court, and some courts have issued temporary stays. But the legal landscape is unstable, and the outcomes are not guaranteed. If you hold TPS, you should be consulting with an attorney right now about what alternative relief, if any, may be available to you. The second issue is denaturalization. This is something that many people assume is virtually impossible, the idea that the United States government could revoke someone's citizenship. But investigations into naturalization fraud have intensified significantly in 2026. Under existing law, a person who obtained citizenship through willful misrepresentation or concealment of a material fact can have that citizenship revoked through a federal civil proceeding. USCIS and DOJ have both indicated that denaturalization investigations are a current enforcement priority, with a specific focus on individuals who failed to disclose criminal history, prior immigration violations, or fraudulent information on their naturalization applications. This does not affect the vast majority of naturalized citizens, but if there is anything in your naturalization application that was incomplete, inaccurate, or that you are concerned about, this is the time to address it with legal counsel, not to wait and hope it is never discovered. The fourth category brings us to geography, and this one affects people across the full spectrum of immigration status. In the 2026 federal budget, $22 billion has been allocated specifically for border and interior immigration enforcement. This is an unprecedented funding level, and it is already translating into visible changes on the ground. ICE is conducting increased street enforcement operations and workplace raids in cities where local law enforcement has policies limiting cooperation with federal immigration agencies, what are commonly referred to as sanctuary cities. The legal foundation for this is the federal government's authority under INA to conduct enforcement operations independently of local cooperation. Court rulings have consistently held that while local jurisdictions can limit their own officers' participation, they cannot legally obstruct federal agents conducting lawful enforcement operations. What this means practically is that living in a city with protective local policies does not create a legal shield. It may reduce certain information sharing, but it does not prevent ICE from conducting its own operations. However, this protection may not be permanent, even in its current limited form. Several legal challenges are working through the courts that could further limit or further protect local sanctuary policies, and outcomes remain uncertain. Now let me give you the action plan, because knowing the risk without having a response to that risk is not enough. Step 1. Audit your immigration history immediately. Go back through every document, every court notice, every visa application, every interaction with immigration authorities. Look for anything incomplete, anything missing, anything that could be misunderstood. Do this before an attorney does it, so you walk into that consultation already organized. Step 2. Verify whether you have any outstanding orders or notices in the immigration court system. The Executive Office for Immigration Review has a public case information line. Your attorney can pull your complete record. Do not assume that no news means no problems. Final orders and in absentia decisions may exist in the system that you are unaware of. Step 3. If you hold TPS, a pending asylum application, an employment authorization document, or any temporary form of status, understand the legal foundation of that status right now and what would happen if it were terminated or denied. Do not wait until a deadline is imminent to start that conversation. Step 4. Do not engage with notarios, immigration consultants who are not licensed attorneys, or anyone offering immigration help who cannot produce a valid bar license. Enforcement pressure always creates space for fraud, and fraud in your immigration case can disqualify you from relief you would otherwise be eligible for. Step 5. Consult a licensed immigration attorney. Not next month. Not when something goes wrong. Now. A single consultation can give you a clear picture of your risk level, your options, and your priorities. I want to take a moment before we close to acknowledge what is actually at stake here, because these are not abstract policy discussions. These are people's lives. Immigration status is not just paperwork. It is family unity. It is whether a parent is present at a child's graduation. It is whether a household has income next month. It is whether 20 years of building a life in this country can continue or comes to an abrupt and devastating end. It is whether a person has a path to citizenship, to full membership in the country they have called home, or whether that door closes permanently. The policy environment in 2026 is serious. The enforcement machinery is larger, faster, and more aggressive than it has been in decades. I'm not saying that to create panic. I am saying it because the response to that reality has to be informed, organized, and legal. Fear without information leads to bad decisions. Information leads to better ones. Stay legal, stay documented, stay connected to qualified legal help, and stay informed, because in an environment where policy is changing this rapidly, what you don't know can genuinely hurt you. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential. If this video helped you understand what is happening right now, please leave a comment below with your visa category or immigration situation. I read every comment, and it helps me understand what you need most. Share this video with someone who has an open immigration case. It could genuinely matter for their future. And if you believe in factual, calm, responsible immigration coverage, hit the like button. It tells YouTube that this kind of content deserves to be seen. I'm Raymond Crivello. Stay informed, stay protected.